I walked out my back door that Tuesday morning expecting to see the gentle creek that had flowed through my property for the past 15 years. But instead, I found a flat stretch of concrete where the water used to run. My coffee mug slipped from my hand and shattered on the porch steps as I stared at what looked like a brand new drainage system cutting straight through my land. The creek was gone, just gone. In its place was this industrial-looking concrete channel that stretched from the western edge of my property all the way to the eastern boundary, and I had no idea how it got there. I jumped off the porch and ran across my yard in my bare feet, not caring about the morning dew soaking my pajama pants. When I reached what used to be the creek bed, I could see that someone had brought in heavy equipment. Tire tracks from massive vehicles were still visible in the mud along the edges. The natural stones that lined the creek were bulldozed to the sides in ugly piles. The willow tree that had stood beside the water for probably 100 years was just gone, leaving behind a stump and sawdust. "What the hell?" I said out loud to nobody. I lived in Cedar Springs, Montana, on a property I inherited from my grandfather. The house sat on 12 acres of beautiful land with pine trees, rolling hills, and that creek running right through the middle of it. My name is Thomas Harding, and I had moved here from Seattle 5 years ago to escape the city life. The property came with something special that my grandfather had made very clear to me before he passed: water rights. He told me those rights were more valuable than gold in Montana, and I needed to protect them at all costs. I ran back inside and grabbed my phone, then stood at the edge of the concrete monstrosity and started taking pictures. The morning light was just getting good, and I made sure to document everything. The tire tracks, the piled stones, the tree stump, all of it. My hands were shaking as I took the photos because I knew this was bad, really bad. That is when I noticed the houses. Beyond my eastern property line, where there used to be nothing but open meadow owned by the county, there were now 5 massive houses under construction. They were those modern McMansion types with fake stone facades and 3-car garages. Construction workers were already moving around the sites, even though it was barely 7 in the morning. I could see the concrete channel I had just discovered connected directly to a drainage system that ran between these new houses. My phone rang in my hand, and I almost dropped it. The caller ID showed my neighbor, Frank Morrison, who lived about a quarter-mile down the road. "Thomas, you see what they did?" Frank's voice was urgent. "I'm looking at it right now," I said. "When did this happen?" "Had to be over the weekend. I drove past your place Friday afternoon and everything looked normal. Yesterday I was in town all day, but when I got back last night, I could see the construction lights over on the east side. I figured I'd call you first thing. You know who authorized this?" "The HOA," Frank said, and I could hear the disgust in his voice. "That new development behind you, Pinecrest Estates or whatever they're calling it, they formed a homeowners association. I heard they needed drainage for all those houses they're building, but I never thought they'd just pave over your creek." I felt my stomach drop. "My creek is on my private property. They can't just do that." "You'd think so, but you know how these HOAs operate. They probably figured it was easier to ask forgiveness than permission. You need to call a lawyer, Thomas, like right now." After I hung up with Frank, I went inside and dug through my grandfather's old file cabinet. I knew exactly what I was looking for: the water rights deed. My grandfather had been meticulous about his paperwork, and everything was organized in labeled folders. I found the deed in a folder marked "Water Rights, Do Not Lose." The document was dated 1952 and signed by the county clerk at the time. It granted my grandfather and all subsequent owners of the property full and exclusive rights to the creek that ran through the land. including all water usage, flow management, and any alterations to the waterway. The language was clear. Nobody could touch that creek without permission from the property owner. The deed also referenced Montana water law, which I knew took water rights very seriously. I made copies of everything and then called the Cedar Springs County Building Department. A woman answered on the third ring. "Building Department, this is Susan." "Hi, Susan. My name is Thomas Harding. I own property at 4782 Old Mill Road, and someone just paved over a creek that runs through my land. I need to know who issued the permit for this work." There was a pause and I could hear typing. "Let me pull up the permits for that area. Can you give me a few minutes? I'll hold." The hold music was some awful instrumental version of a Eagles song. I paced around my kitchen while I waited, looking out the window at the concrete channel that had replaced my beautiful creek. 3 minutes later, Susan came back on the line. "Okay, Mr. Harding, I found the permit. It was issued 2 weeks ago to the Pinecrest Estates HOA for drainage infrastructure related to the new residential development. The permit application shows the work area extending through parcel 45,789,003, which is listed as common area property." "That's my parcel number," I said. "But it's not common area property. It's my private land." More typing sounds. "Sir, according to the records I'm looking at, parcel 45,789,003 was designated as common area during the Pinecrest Estates development planning phase. The notation says it was approved by the county commission last year." I felt anger rising in my chest. I never sold or transferred any of my land to anyone. This is private property that's been in my family since 1947. Someone made a mistake. "You'll need to speak with the county assessor's office about property records," Susan said. Her voice had taken on that bureaucratic tone that people use when they don't want to deal with a problem. "I just handle building permits based on what the system tells me. Can you tell me who signed off on this permit?" "That would be Brenda Carmichael, the HOA president for Pinecrest Estates. Her contact information is on file if you need it. Of course it was someone named Brenda." I took down her number and then called the county assessor's office. They couldn't see me until Thursday, which meant I had to wait 2 days to sort out how my property suddenly became classified as common area. I spent the rest of Tuesday making phone calls to lawyers. The first 3 I tried didn't handle property disputes. The fourth one, Daniel Price, agreed to meet with me Wednesday morning. That evening I walked down to the construction site. The workers had left for the day, but there were signs posted everywhere. Pinecrest Estates, a premium HOA community and future home of Cedar Springs' most exclusive neighborhood. The houses were in various stages of construction, with the furthest along already having windows installed. I could see that the concrete drainage channel ran directly from my property through the middle of the development, and then connected to the county storm drain system on the far side. Someone had planted metal stakes along what they thought was the property line between my land and the development. I pulled out my phone and opened the GPS property app that showed official boundary lines. According to the app, those stakes were about 40 feet onto my side of the actual property line. They had not only paved my creek, they had also built their drainage system partially on my land. I took more pictures as the sun set, making sure to capture the GPS coordinates in each photo. Then, I noticed a black SUV pulling up the construction road toward me. It parked next to a construction trailer, and a woman got out. She was probably in her mid-50s, wearing expensive yoga pants and a designer jacket, despite the fact that she was at a muddy construction site. Her blonde hair was cut in that aggressive bob that seemed to be required for a certain type of suburban woman, and she walked toward me with the confidence of someone who always got her way. "Excuse me, this is private property," she called out when she was about 20 feet away. "You need to leave." "I'm on my property," I said, not moving. "You're the one who needs to leave." She stopped and put her hands on her hips. "This is Pinecrest Estates common area. I'm Brenda Carmichael, the HOA president, and I'm telling you that you're trespassing." "Brenda Carmichael," I said. "You're exactly who I wanted to talk to. I'm Thomas Harding, and you paved over a creek that runs through my private property. Not common area, my property." Her expression didn't change. "I don't know what you're talking about." The drainage system was installed on HOA property according to all proper permits and regulations. If you have a concern, you can submit it in writing to the HOA board. "I have water rights to that creek dating back to 1952, I said, holding up my phone with a photo of the deed on the screen. "You destroyed private property without permission. That's illegal." Brenda barely glanced at my phone. "Water rights don't supersede county development plans. The area where the drainage was installed was designated as common area by the county commission specifically for infrastructure purposes. We followed all the rules. Nobody asked for my permission or even notified me. Because we didn't need to," she said. Her voice had this condescending tone like she was explaining something to a child. "Look, Mr. Harding, I understand you're upset, but this is progress. This development is going to bring a lot of value to the area. That muddy little creek was an eyesore anyway. Now we have proper drainage that will prevent flooding and erosion." I felt my jaw clench. That creek wasn't an eyesore. It was a natural waterway with its own ecosystem. You destroyed it. "I improved it," Brenda said. "And if you continue to harass me or interfere with our construction, I'll call the sheriff. Have a nice evening." She turned and walked back to her SUV without waiting for a response. I watched her drive away and then looked back at the concrete channel that used to be my creek. The anger I felt was mixed with something else, determination. Brenda Carmichael clearly thought she could bulldoze over people the same way she bulldozed over my property. She was about to learn otherwise. Wednesday morning, I met with Daniel Price at his law office in downtown Cedar Springs. Daniel was in his early 40s with graying hair and the kind of steady demeanor that probably served him well in court. His office was filled with law books and filing cabinets, and he had a map of Cedar Springs County spread out on his conference table when I arrived. "Mr. Harding, thanks for sending over all those documents last night," Daniel said as we shook hands. "I've had a chance to review your water rights deed and the photos you took. This is quite a situation." I sat down and he slid a legal pad across the table toward me. "Before we get into strategy, I need to understand the timeline. Walk me through everything that happened." I spent 20 minutes explaining the whole story, from discovering the paved creek to my confrontation with Brenda Carmichael. Daniel took notes and asked questions about specific details. When I finished, he leaned back in his chair and tapped his pen against the legal pad. "Okay, here's what I think is happening," he said. "The Pinecrest Estates developers needed drainage for their project. Natural waterways can be complicated when you're building because you have to work around them and maintain certain buffer zones. So someone, probably the developer or Brenda herself, went to the county commission and got them to reclassify your creek area as common area. That gave them the legal cover to pave it over and incorporate it into their drainage system." "But it's my property," I said. "How can the county just reclassify private land? They can't. Or at least they shouldn't be able to. But here's the thing. These processes involve a lot of paperwork and public hearings. If nobody shows up to object, The commission can push things through pretty easily. Did you receive any notice about a public hearing regarding your property? I thought back through the past year. No, nothing. That's where they messed up, Daniel said. He opened a folder and pulled out a document. Montana law requires property owners to be notified in writing if there's any action being taken that could affect their property rights. The county should have sent you a certified letter about the reclassification hearing. If they didn't, the whole thing is invalid. So what do? First, we confirm at the county assessor's office tomorrow that no proper notification was sent. Then, we file an emergency motion to halt all construction related to the drainage system until the property dispute is resolved. After that, we sue the HOA and the developers for trespass, destruction of property, and violation of your water rights. I felt a small sense of relief. How long will this take? Daniel grimaced. That's the hard part. Cases like this can drag on for months or even years. But given how egregious this situation is, I think we have a good shot at getting a preliminary injunction pretty quickly. Maybe within a week or two. The water rights deed you have is solid gold, by the way. Montana courts take water rights very seriously, especially historic ones like yours. We spent another hour going over the details and discussing legal fees. Daniel agreed to take the case on a contingency basis plus costs, which meant he wouldn't get paid unless we won. That told me he was confident. By the time I left his office, I felt like I finally had a plan. Thursday morning at the county assessor's office, things got interesting. The assessor, a tired-looking man in his 60s named Robert Chen, pulled up the records for my property and just stared at his computer screen for a long moment. "This doesn't make any sense," he said finally. Daniel and I were sitting across from his desk. "What doesn't make sense?" Daniel asked. "The record shows that parcel 45,789,003 was reclassified as common area in August of last year following a county commission vote. But there's no documentation showing that the property owner was notified. There should be a signed receipt for certified mail delivery, but there's nothing in the system. So the reclassification was done improperly," Daniel said. Robert nodded slowly. "It appears so. Let me check something else." He typed for a minute and then shook his head. "This is worse than I thought. The property description in the reclassification order doesn't match the legal description in Mr. Harding's deed. They're off by about 200 feet. Whoever prepared the reclassification documents used the wrong parcel information." "What does that mean?" I asked. "It means they reclassified property that doesn't exist," Robert said. "The legal description they used doesn't correspond to any actual parcel. This whole thing is invalid, not just improper, but completely void." Daniel pulled out his phone and started taking pictures of Robert's computer screen. "Can you print all of this out for us?" "Absolutely. And I'm going to recommend to the county commission that they reverse the reclassification order immediately. This is a major error." We left the assessor's office with a stack of documents proving that the county had made a massive mistake. Daniel was practically bouncing as we walked to his car. "This is even better than I thought," he said. "We're not just talking about improper notification. The entire legal basis for the HOA's actions is void. That means they knowingly destroyed your property without any legal authority whatsoever. So what happens now? Now we go nuclear. I'm filing for an emergency hearing tomorrow. We're going to ask the judge for an immediate restraining order against the HOA and an order to restore your creek to its original condition." The emergency hearing was scheduled for Monday morning, which gave me a long weekend to stew over everything. I spent Saturday walking my property and documenting every bit of damage the HOA had caused. Beyond the paved creek, I found that they had also cleared about an acre of trees on my land to make room for their drainage system. They had dumped construction debris along my property line. And worst of all, I discovered that paving the creek had created a flooding problem. The natural creek had absorbed rainwater and allowed it to percolate into the ground. The concrete channel just rushed water downstream as fast as possible, which meant it was now pooling in low-lying areas of my property where it never used to collect. Sunday afternoon, Brenda Carmichael showed up at my door. I saw her SUV pull into my driveway, and I met her on the front porch before she could knock. "Mr. Harding, we need to talk," she said. Her voice was still condescending, but I detected a hint of nervousness underneath. "My lawyer told me not to speak with you directly," I said. "Oh, come on, we're neighbors. We should be able to work this out like adults." She gave me what I'm sure she thought was a winning smile. "Look, I heard you went to the county offices this week. I want to clear up any misunderstanding about the property situation." "There's no misunderstanding. You paved my creek without permission, and you did it based on a county order that used the wrong property description. The whole thing is void." Her smile faded. "Okay, fine. Maybe there was some confusion with the paperwork, but the fact remains that we need that drainage system. The development won't work without it. I'm prepared to offer you compensation." "I don't want compensation. I want my creek back." "That's not reasonable," Brenda said, and now her voice had an edge to it. "We've already spent hundreds of thousands of dollars on the drainage system. You can't expect us to just rip it all out. You should have thought about that before you destroyed my property." She stared at me for a long moment, and I could see her trying to control her anger. "Mr. Harding, I'm trying to be nice here. But if you push this, things are going to get very unpleasant. The HOA has significant resources, and we will fight you every step of the way. Wouldn't it be better to just accept a reasonable payment and move on?" "Get off my property," I said. "You're making a huge mistake," Brenda said. "When we're done, you'll wish you had taken my offer." She walked back to her SUV, and I watched her drive away. My hands were shaking slightly. I had never been the kind of person who enjoyed confrontation, but something about Brenda's entitled attitude made my blood boil. She genuinely seemed to believe that she could do whatever she wanted as long as she threw enough money around. Monday morning, Daniel and I arrived at the Cedar Springs County Courthouse at 8:30. The emergency hearing was scheduled for 9. We set up in the courtroom, and Daniel arranged his documents on the table. At 8:45, a lawyer I had never seen before walked in with Brenda Carmichael and two men in expensive suits who I assumed were the developers. The lawyer introduced himself as Marcus Webb, and he had that slick corporate attorney look, perfectly tailored suit, expensive watch, confident handshake. "Daniel, good to see you," he said. "I'm hoping we can resolve this without wasting the court's time." "That would be great," Daniel said. "Your client can start by agreeing to restore my client's property and pay damages." Marcus laughed. "Come on, be serious. We're prepared to offer Mr. Harding $50,000 to settle this whole thing. That's more than generous given the minimal impact to his property." "Minimal impact?" I said. "You destroyed an entire creek." "We improved a drainage area," Marcus said smoothly. "And that improvement benefits everyone in the area, including you." Before I could respond, the bailiff called the court to order. Judge Patricia Morrison entered, and we all stood. She was a woman in her late 50s with sharp eyes and no-nonsense demeanor. I had done some research over the weekend and learned that Judge Morrison had a reputation for being extremely thorough and not tolerating any games in her courtroom. "Be seated," Judge Morrison said. "I've reviewed the emergency motion filed by the plaintiff, Thomas Harding, and the response from the defendants. Mr. Price, This is your motion, so you can begin." Daniel stood up. "Thank you, Your Honor. This is a straightforward case of trespass and destruction of property." The defendants, led by the Pinecrest Estates HOA and its president Brenda Carmichael, paved over a natural creek that runs through my client's private property. They did this based on a county commission order that used the wrong property description and failed to provide proper notification to my client. We have documentation proving that the entire legal basis for their actions was void. He walked through the evidence methodically. My water rights deed, the photos of the destroyed creek, the documents from the county assessor showing the error in the property description, and the lack of any notification to me. Judge Morrison listened carefully and took notes. When Daniel finished, Marcus Webb stood up. "Your Honor, the plaintiff is trying to manufacture a crisis where none exists. Yes, there may have been some minor clerical errors in the county's paperwork, but the intent was clear. The drainage area needed to be developed for the good of the community. My clients relied on proper permits and approvals. They acted in good faith throughout this process." "Good faith," Judge Morrison said. "Mr. Webb, your clients paved over a creek on someone else's property. How is that good faith?" "We believed it was common area property, Your Honor. The county told us it was. Based on documents that used the wrong property description and failed to notify the actual property owner," Judge Morrison said. "That's not good faith, that's negligence at best." Marcus opened his mouth to respond, but Judge Morrison held up her hand. "I've heard enough for now. Let me ask you directly, Mr. Webb. Does your client dispute that the creek in question runs through Mr. Harding's private property?" "Your Honor, we believe the property boundaries are unclear, and that's not what I asked. The property records clearly show parcel 45,789,003 belongs to Mr. Harding and has belonged to his family since 1947. The creek runs through that parcel. Do you dispute these facts?" Marcus hesitated. "No, Your Honor, we don't dispute that." "Then your clients committed trespass when they paved the creek without Mr. Harding's permission." "Is that correct, Your Honor? We're prepared to offer compensation." "Mr. Webb, answer my question. Did your clients commit trespass?" "Technically, yes, but there's no but in trespass law," Judge Morrison said. She looked down at her notes and then back up at Marcus. "Here's what's going to happen. I'm issuing a temporary restraining order prohibiting any further construction on or near Mr. Harding's property. The defendants will cease all work related to the drainage system immediately. I'm also ordering an independent survey of the property to establish the exact boundaries and extent of the damage." "Your Honor, that will shut down our entire development," Marcus said. "We have contracts, deadlines. You should have thought about that before you paved over someone's creek," Judge Morrison said. "I'm scheduling a full hearing for 3 weeks from today. At that hearing, I'll decide whether to issue a permanent injunction and what damages, if any, are appropriate." "Mr. Harding, I see you have a water rights deed. I want you to bring the original to the full hearing, along with any other documentation about the creek's history." "Yes, Your Honor," I said. "One more thing," Judge Morrison said. She looked directly at Brenda Carmichael. "Madam, are you the HOA president?" Brenda stood up. "Yes, Your Honor. Did you personally authorize the paving of this creek?" "Yes, I did, but you thought wrong. And from what I'm reading in these documents, you were told by Mr. Harding that he owned the property and you proceeded anyway. Is that accurate?" Brenda's face went red. "He didn't have proof at the time. He told you it was his property and you didn't bother to verify before continuing your construction. That's not just negligence, that's willful disregard for someone else's property rights." Judge Morrison shook her head. "I suggest you hire better advisors, madam. This court is adjourned." The gavel came down, and I felt like I could breathe for the first time in days. Daniel was grinning as we packed up our documents. Marcus Webb and his clients left the courtroom quickly, but I caught Brenda giving me a look of pure hatred before she walked out. "That went about as well as it possibly could have," Daniel said. "Judge Morrison basically told them they're screwed. We just need to keep building our case for the full hearing." Over the next 3 weeks, a lot happened. The independent surveyor came out and confirmed that the concrete channel was entirely on my property, and that the HOA had also encroached on my land with their drainage system infrastructure. The survey showed that I had lost about 1.8 acres of usable property due to the paving and construction debris. A local environmental group caught wind of the case and sent their own expert to assess the damage. The expert, a hydrologist named Dr. Sarah Chen, wrote a detailed report about the ecological impact of paving the creek. She found that the destruction had eliminated habitat for several species of fish and amphibians, disrupted the natural water filtration system, and increased erosion and flooding risk in the surrounding area. Her report concluded that the damage was severe and would take years to fully restore even if work started immediately. Meanwhile, the construction at Pinecrest Estates ground to a halt. The restraining order meant they couldn't do any work on the drainage system, and without a functioning drainage system, they couldn't complete the houses. I drove past the development one afternoon and saw the half-finished homes just sitting there with no workers in sight. A new sign had been added to the entrance. "Development temporarily delayed." Brenda called me twice more to try to negotiate, but I refused to talk to her. The second time she called, she left a voicemail that was borderline threatening. "You're destroying a $100 million development over a little creek," she said. "People are going to lose their jobs. Families who bought these homes won't be able to move in. This is on you, Mr. Harding. I hope you can live with yourself." I deleted the voicemail and forwarded a copy to Daniel. He said it might be useful if things escalated further. 2 days before the full hearing, something interesting happened. Frank Morrison called me with some news he had heard through the local grapevine. Apparently, the Pinecrest Estates developers were in serious financial trouble. They had borrowed heavily to finance the construction, and the delays were costing them hundreds of thousands of dollars a week. Several of the buyers who had put deposits on homes were threatening to sue for non-delivery. The whole project was teetering on the edge of collapse. "They're going to come at you hard at the hearing," Frank said. "They'll try to paint you as the villain who's holding up progress. Just be ready for it." The full hearing was held on a Thursday morning in a larger courtroom than the emergency hearing. This time there were reporters present and about 20 people in the gallery. Marcus Webb brought a team of 3 other lawyers, and they had multiple boxes of documents. Brenda Carmichael was there with the developers and several people I didn't recognize who were probably experts they had hired. Judge Morrison came in, and we all stood. She looked around the crowded courtroom and raised an eyebrow. "Well, this certainly generated some interest. Let's get started. Mr. Price, you can present your case." Daniel stood and methodically walked through everything. He presented my water rights deed, the survey results, Dr. Chen's environmental report, and photos showing the before and after condition of my property. He also submitted evidence of the county's error in the reclassification order and the lack of notification to me. Finally, he played Brenda's threatening voicemail for the court. "Your Honor, this is a clear case of trespass, destruction of property, and violation of historic water rights," Daniel said. "The defendants had no legal authority to touch my client's creek. They were informed it was private property and proceeded anyway." They caused extensive environmental damage and significantly diminished the value and usability of my client's land. We're asking the court to order full restoration of the creek to its natural state and award substantial damages. Marcus Webb's turn took much longer. He brought up expert after expert to testify about the importance of the Pinecrest Estates development to the local economy, the technical difficulties of reversing the drainage work, and the supposedly minimal impact to my property. One expert claimed the concrete channel was actually better than the natural creek because it prevented flooding. That's when Daniel called Dr. Chen to rebut. She destroyed that argument in about 5 minutes, explaining how the natural creek had provided essential flood control through absorption and percolation, while the concrete channel had actually increased flooding on my property. Then Marcus tried a different angle. Your Honor, even if we accept that mistakes were made, the remedy my friend is requesting is disproportionate. He wants us to tear out hundreds of thousands of dollars of infrastructure over a small creek. That's not reasonable. A monetary settlement would be more appropriate. Judge Morrison leaned forward. Mr. Webb, I've been listening to your arguments all morning and I keep coming back to the same question. Why should Mr. Harding be forced to accept money instead of having his property restored? He didn't choose to have his creek paved. Your clients did that without his permission. Your Honor, the practical reality is that your clients committed trespass and they should fix what they broke, Judge Morrison said. But I'll let you continue. Marcus spent another hour trying to convince the judge that restoration was impossible or too expensive or would take too long. None of it seemed to be landing. Finally, Judge Morrison called for a break. During the break, Daniel and I stood in the hallway. I think we've got this, he said quietly. Judge Morrison is clearly on our side. The question is what remedy she's going to order. I just want my creek back, I said. You might get that and more. The environmental damage alone could justify significant punitive damages. When we returned to the courtroom, Judge Morrison had some questions. Mr. Harding, can you please stand? I stood up, my heart pounding. Mr. Harding, I've reviewed your water rights deed very carefully. This is a historic document granting your family exclusive rights to the creek dating back to 1952. In your own words, what does this creek mean to you? I took a breath. Your Honor, that creek has been part of my family's land for 3 generations. My grandfather used to take me fishing there when I was a kid. It's not just water flowing through my property. It's a living ecosystem. There were trout in that creek. There were frogs and turtles. Deer came to drink from it. It was beautiful and natural, and now it's just concrete. I understand the HOA needed drainage for their development, but they could have worked around the creek or built their system somewhere else. They chose the easy route without caring whose property they destroyed. Judge Morrison nodded. Thank you. You can sit down. She looked at her notes for a long moment and then began speaking. I've heard all the evidence and arguments, and this is my ruling. First, I find that the defendants, Pinecrest Estates HOA, Pinecrest Development LLC, and Brenda Carmichael in her capacity as HOA president, committed willful trespass on the plaintiff's property. They paved over a natural creek without legal authority and without the property owner's permission. They were informed that the property was private, and they proceeded anyway. This was not a good faith mistake. This was a deliberate decision to prioritize their commercial interests over someone else's property rights. I felt Daniel squeeze my shoulder. Second, I find that the County Commission's reclassification order was void from the beginning due to the incorrect property description and failure to provide proper notification. The defendants cannot rely on that order as legal justification for their actions. Third, I find that the water rights deed held by Mr. Harding is valid and enforceable. Montana law protects water rights, especially historic ones like this. The defendants violated those rights when they paved the creek. Marcus Webb was scribbling notes frantically. Now, as to remedies. The defendants argue that monetary damages are sufficient and that restoration is too difficult or expensive. I reject that argument. When someone trespasses and destroys property, the first remedy is to restore the property to its original condition if possible. Money is only appropriate when restoration is truly impossible. I am therefore ordering the defendants to fully restore the creek to its natural state within 90 days. This includes removing all concrete and infrastructure installed on Mr. Harding's property, restoring the natural creek bed and banks, replanting appropriate vegetation, and mitigating any erosion or flooding damage caused by the paving. The restoration work will be overseen by an independent environmental expert approved by both parties. Brenda Carmichael made a noise that sounded like a strangled gasp. In addition, I am awarding Mr. Harding compensatory damages in the amount of $200,000 for the loss of use of his property, the environmental damage, and the stress and inconvenience this situation has caused. I am also awarding punitive damages in the amount of $300,000. The purpose of punitive damages is to punish wrongdoing and deter similar conduct in the future. The defendant's behavior in this case was egregious enough to warrant substantial punishment. Finally, I am awarding Mr. Harding his attorney's fees and costs, which will be calculated and submitted within 30 days. The courtroom was silent. I couldn't quite believe what I was hearing. Daniel was grinning beside me. The defendants have 90 days to complete the restoration work, Judge Morrison continued. If they fail to do so, Mr. Harding may hire contractors to do the work and bill the defendants for the cost. The monetary damages will be paid within 30 days. Are there any questions? Marcus Webb stood up slowly. Your Honor, we intend to appeal this decision. That's your right, Mr. Webb, but the order for restoration stands pending any appeal. This court is adjourned. The gavel came down and suddenly everyone was talking at once. Reporters rushed toward Marcus and his clients. Daniel shook my hand and then pulled me into a hug. We did it, he said. That's one of the best outcomes I've ever seen in a property case. I felt like I was in a daze. $500,000 plus fees plus the restoration of my creek. It seemed almost too good to be true. The reporters tried to interview me, but Daniel steered me out a side door. Don't talk to them yet, he said. Let's get the written order first and make sure everything is finalized. Outside the courthouse, Frank Morrison was waiting by my truck. I heard you won, he said. The whole town's going to be talking about this. I can't believe it actually worked, I said. You had the law on your side, Frank said, and Judge Morrison doesn't mess around. She's been waiting for a case like this to send a message to these HOA types who think they can do whatever they want. Over the next few days, the news spread fast. The local newspaper ran a front-page story. Judge orders HOA to restore creek in property rights case. The article included details about the $500,000 judgment and featured a photo of the paved creek next to an old photo from my grandfather's collection showing what it used to look like. The story got picked up by regional news outlets and then by some national ones. Suddenly, I was getting calls from reporters all over the country wanting to talk about HOA overreach and property rights. I did a few interviews at Daniel's suggestion, figuring it might help prevent the defendants from trying any funny business during the appeal process. The Pinecrest Estates development went into chaos. Two of the developers filed for bankruptcy protection within a week of the judgment. The HOA tried to levy special assessments on the few homeowners who had already closed on properties to pay for the damages, which led to several lawsuits from those homeowners against the HOA. Brenda Carmichael resigned as HOA president and disappeared from public view. But here's where things got really interesting. About 3 weeks after the judgment, I got a call from Daniel asking me to come to his office immediately. When I arrived, there was a detective from the Montana State Police waiting with him. The detective introduced himself as Detective Ray Collins. "Mr. Harding, thank you for coming in. I'm investigating possible fraud related to the Pinecrest Estates development, and I have some questions about the county reclassification order." "Okay," I said, sitting down. "We've been looking into how your property got reclassified as common area despite the obvious errors in the paperwork. What we found is concerning. It appears that someone paid a county clerk to push through the reclassification without proper review or notification. We have bank records showing a $20,000 payment from an account controlled by Brenda Carmichael to a clerk in the county planning department 2 weeks before the reclassification was approved." I felt my jaw drop. So it wasn't just negligence, it was deliberate fraud. "That's what it looks like," Detective Collins said. "The clerk has been arrested and is cooperating with our investigation. He's claiming that Miss Carmichael approached him and offered money to expedite the reclassification and make sure nobody asked too many questions. She allegedly told him that you had already agreed to the easement, but the paperwork was held up." "That's a complete lie," I said. "I never spoke to Brenda about any easement until after the creek was already paved." "That's what we figured. The clerk says he's willing to testify against Miss Carmichael in exchange for a reduced sentence. We're preparing to file criminal charges against her for bribery, fraud, and conspiracy. I wanted to let you know because it might affect your civil case." Daniel was nodding. "If Brenda is charged criminally, it strengthens our position if they try to appeal. It shows this wasn't just a civil trespass, it was part of a criminal conspiracy to steal your property rights." Over the following weeks, the criminal investigation expanded. It turned out that Brenda Carmichael had been running schemes like this for years at various developments around Montana. She would identify properties that were inconvenient for development, find ways to reclassify them or get easements through dubious means, and then profit when the developments went forward. In some cases, she had bribed officials. In other cases, she had forged signatures on easement agreements. My case was just the first time someone had fought back hard enough to expose the whole operation. Brenda was arrested in early June and charged with multiple counts of bribery, fraud, forgery, and conspiracy. The prosecutors also charged 2 of the Pinecrest developers who had allegedly known about the bribes and helped facilitate them. The story became a huge scandal in Montana real estate circles. Meanwhile, what was left of the Pinecrest Estates HOA hired new leadership and new lawyers. The new HOA president, a reasonable guy named Tom Fletcher, reached out to Daniel to discuss the restoration work. "We want to comply with the judge's order," Tom said when we met at Daniel's office. "The problem is that the original developers are bankrupt and we don't have the funds to do the full restoration. We're hoping we can work out a payment plan or some kind of compromise." I looked at Daniel and he shrugged, leaving it up to me. I thought about it for a minute. The new HOA leadership wasn't responsible for what Brenda had done. The homeowners who had bought into Pinecrest were victims too. "Here's what I'll agree to," I said. "You can pay the monetary damages over 3 years instead of 30 days, interest-free." But the restoration work has to start immediately and be completed within the 90-day deadline. You need to find the money for that somewhere. Tom nodded. That's fair. We'll take out a loan if we have to. We just want to make this right. We drew up a new agreement with those terms and submitted it to Judge Morrison for approval. She signed off on it, and the work began in mid-June. Watching the restoration was incredible. A team of environmental contractors came in with excavators and carefully removed all the concrete from the creek bed. They hauled away tons of debris and then brought in natural stones and gravel to rebuild the creek banks. A landscape architect designed a plan to restore the vegetation, including replacing the old willow tree with 2 new ones. The hardest part was re-establishing the water flow. The creek had been dry for months, and the natural springs that fed it had been disrupted by the paving. The contractors had to dig down to find the original water sources and clear the channels. It took 3 weeks, but eventually water started flowing again. By early August, my creek was back. It didn't look exactly like it had before. That would take years of natural growth and settling. But it was a real creek again, with clear water running over stones and native plants growing along the banks. Fish would return eventually, and so would the frogs and turtles and all the other wildlife. I stood on my back porch one evening in mid-August watching the sun set over the creek and felt a sense of peace I hadn't felt since this whole nightmare began. Frank Morrison came by with a 6-pack of beer and we sat on the porch. "You did good, Thomas," Frank said. "You could have taken their money and let them keep the concrete. A lot of people would have." "It was never about the money," I said. "My grandfather trusted me to protect this land. I couldn't let some HOA destroy it just because they thought they could." "Well, you made quite a statement." "I hear HOAs all over the state are being a lot more careful about property rights now. Nobody wants to end up like Pinecrest Estates." We drank our beers and watched the creek. In the fading light, I could see trout rising to catch insects on the water's surface. They had come back faster than I expected. The criminal trial for Brenda Carmichael happened in October. I had to testify about my interactions with her and about the damage to my property. Seeing her in court was surreal. She looked smaller somehow, diminished. The confident, condescending woman who had told me I was making a huge mistake now sat quietly at the defense table looking defeated. The evidence against her was overwhelming. The clerk she had bribed testified in detail about their arrangement. Prosecutors presented bank records, emails, and testimony from other property owners she had targeted over the years. The jury convicted her on all counts after just 4 hours of deliberation. The judge sentenced Brenda to 4 years in federal prison and ordered her to pay restitution to all her victims, including me. She was also fined and permanently banned from holding any position in an HOA or similar organization. 2 of the developers who had been charged took plea deals and received shorter sentences. By the time everything was finally wrapped up, it was November. The Pinecrest Estates development had been taken over by a new management company that seemed determined to run things properly. They completed the unfinished houses without any further encroachment on my property, and the homeowners were finally able to move in. Tom Fletcher, the new HOA president, came by one Saturday morning with a gift basket and an apology. "On behalf of everyone at Pinecrest, I want to say we're sorry for what happened," he said. "What Brenda did was inexcusable. We're trying to build a real community here, not the kind of place that tramples on people's rights." "I appreciate that," I said. "And for what it's worth, I don't have anything against your residents. They didn't do anything wrong." "Well, if you ever need anything, you let us know. You're our neighbor and we want to be good neighbors." After he left, I walked down to the creek. The willow trees that had been planted in the spring were thriving, already about 8 feet tall. The creek was flowing clear and strong, and the ecosystem was healing. I had kept every penny of the judgment money in a separate account, planning to use it for conservation easements and habitat restoration on my property. My grandfather would have approved. I thought about everything that had happened over the past year. If someone had told me 12 months ago that I would be fighting an HOA in court over water rights, testifying in a criminal trial, and becoming a minor celebrity in property rights circles, I never would have believed it. But standing there by the restored creek, I felt proud of what I had accomplished. The thing about property rights is that they only matter if you're willing to defend them. Brenda Carmichael and her cronies had counted on me being too intimidated or too apathetic to fight back. They thought they could just bulldoze through because that's what they had always done before. They learned the hard way that some things are worth fighting for. My phone buzzed with a text from Daniel. New client just called. HOA in Billings paved over his garden to build a dog park. Reminded me of your case. Want to talk to him? I smiled and typed back. Give him my number. I'll tell him my story. The sun was setting over the mountains and the creek was singing its evening song. I took a deep breath of the cool Montana air and headed back to the house. There was work to do, but for now, I just wanted to enjoy the peace of knowing that my land, my creek, and my grandfather's legacy were safe. The legal fees had been calculated at $90,000, which the HOA paid without objection. Combined with the $500,000 in damages, I had more money than I knew what to do with. But money had never been the point. The point was justice. The point was standing up to bullies who thought they could take whatever they wanted just because they had power and resources. In December, a local environmental group gave me an award for outstanding protection of natural resources. The award ceremony was at a fancy hotel in Cedar Springs, and there were about 100 people there. When I accepted the award, I kept my speech short. I didn't set out to be anyone's hero, I said. I just wanted to protect a creek that my family has cared for through 3 generations. But I learned something important through this experience. Our natural resources are precious and irreplaceable. Once they're gone, they're gone. We all have a responsibility to protect them, not just for ourselves, but for future generations. Thank you for this honor. The audience applauded, and afterward several people came up to talk to me about their own battles with HOAs and developers. It seemed like my case had struck a nerve. People were tired of being pushed around by organizations that seemed to have forgotten they were supposed to serve their communities, not rule over them like little fiefdoms. That night, I drove home and parked in my driveway. The December sky was clear and full of stars. I could hear the creek even from the driveway, a gentle rushing sound that had been part of the background of this land for hundreds of years. I had almost lost it, but through a combination of luck, good legal help, and sheer stubbornness, I had gotten it back. I thought about calling my mother to tell her about the award, but it was late on the East Coast. I would call her tomorrow. She had been following the whole saga from Florida and had told me repeatedly how proud my grandfather would have been. As I walked toward my house, I noticed something moving near the creek. I grabbed a flashlight from my truck and walked down to investigate. What I found made me stop in my tracks. A doe and her fawn were drinking from the creek, their heads dipping gracefully to the water. They looked up when my flashlight beam caught them, their eyes reflecting the light, and then bounded away into the darkness. Wildlife was returning. The creek was healing. Justice had been served, and I had learned that sometimes the hardest fights are the ones most worth fighting. I went inside, made myself dinner, and spent the evening reading by the fireplace. Outside, the creek flowed on through the darkness as it had for centuries. as it would for centuries to come. And somewhere in federal prison, Brenda Carmichael was learning that some people value principles more than convenience, and that trying to steal someone's heritage has consequences. The whole experience had changed me. I was more confident now, more willing to speak up when I saw something wrong. I had also become something of an accidental activist, regularly speaking with property owners who were facing similar battles with HOAs and developers. Daniel and I had even discussed writing a guide for property owners on how to protect their rights. As winter settled over Montana and snow began to cover the ground, I spent my evenings planning improvements for the property. I wanted to create a conservation easement that would permanently protect the creek and the surrounding land from development. I wanted to document the history of the property and my family's stewardship of it. And I wanted to make sure that my grandfather's legacy would live on long after I was gone. The last of the Pinecrest Estates homes sold in January, and the development was finally complete. It looked nice enough, and the new homeowners seemed decent. A few of them had even stopped by to introduce themselves and apologize for the trouble their HOA had caused. I appreciated the gesture. One evening in late January, almost exactly a year after the creek had been paved, I received an unexpected visitor. It was Robert Chen, the county assessor who had helped expose the errors in the reclassification order. "Mr. Harding, I hope I'm not intruding," he said when I answered the door. "Not at all. Come in." We sat in my living room and Robert explained why he had come. "I wanted to thank you personally. Your case exposed some serious problems in our county processes. After everything came out about the bribes and the fraudulent paperwork, we did a complete audit of all our property records and commission decisions from the past 5 years. We found dozens of irregularities. Some of them were honest mistakes, but several appeared to be cases similar to yours where property rights were being manipulated for private gain." "That's good that you found them," I said. "We've implemented new safeguards now. Multiple levels of review, mandatory notification to property owners for any action affecting their land, and better oversight of the commission process. What happened to you should never happen to anyone else." "I'm glad something good came out of all this." Robert nodded. "There's one more thing. The county wants to formally apologize for the role our errors played in this situation. We're prepared to offer compensation for I held up my hand. I don't want money from the county. Your office made a mistake, but you weren't part of the conspiracy. Once you realized what happened, you did the right thing. That's enough for me." Robert looked relieved. "Thank you, Mr. Harding. That's very generous." After he left, I walked down to the creek one more time. The water was partially frozen now, ice forming along the edges and creating beautiful patterns in the moonlight. But underneath the ice, the water still flowed, still carried life, still connected my land to the greater watershed that stretched across Montana. I thought about my grandfather and all the times he had brought me to this spot. He used to say that land wasn't something you owned. Not really. You were just a temporary caretaker, responsible for passing it on to the next generation in at least as good a condition as you received it. I had almost failed in that responsibility, but I had fought hard enough to succeed. The creek flowed on, eternal and beautiful, a testament to the power of standing up for what's right, no matter how difficult the fight. And somewhere in the darkness, I could hear the sound of the willow trees creaking in the winter wind, already growing strong, already becoming part of the landscape again. It had been a hell of a year, but standing there in the cold January night, listening to the creek and the wind and the distant howl of a coyote, I felt at peace. The battle was over. The creek was saved. And I had proven that even against powerful organizations with deep pockets and political connections, One person with the law on their side could still win. That was the end of the story, but it was also a beginning. A beginning of better protections for property owners in Cedar Springs County. A beginning of more careful oversight of HOAs and their power. A beginning of renewed respect for historic property rights and natural resources. And for me personally, a beginning of a life lived with the confidence that comes from knowing you stood your ground when it mattered most. The creek would flow on long after I was gone, and future generations would enjoy its beauty and its bounty, never knowing how close it came to being paved over and lost forever. That was exactly how my grandfather would have wanted it, and that was exactly how I would ensure it stayed.